There you go.
Okay, folks. A few things I wrote down that I said I should say at the outset. One thing is that I don't know how many of you saw. There were a couple of. I put out my thing about how this was, the small time people that got all the way to the Supreme Court and blah blah blah. And a couple of people wrote back and said, "Oh boy, I want to see the good guys win in the Supreme Court for once." And somebody else said, "This is David and Goliath." I really like that story, and I want to correct that impression. Um, because well, I leave it up to you to decide. But I'm not saying that we were the good guys. Let me make that very clear. And in terms of David versus Goliath, I think the better analogy would be that after David uh, slew Goliath with the slingshot, a little buddy of a little tiny buddy of Goliath's come up and kills David with a pea shooter. So uh, that's sort of you could make an argument that that's what we did. But I'm not advocating one way or another about whether we were the good guys or the bad guys, and that some of that'll come up later. So yeah, let me say, if anybody has questions, obviously, especially when the sh screen is shared, it'll be hard for me to see you, so just yell out. And if I digress, you could just yell out, "Get on with it." Or if I say something that some of you, because people are professionals in this area, and they will either the medical or the legal, and they will say that's not right. Yeah, but feel free to say that because uh, I'm uh, I'm sure that I'm going to say a lot of stuff that's not actually right. But anyway, and I'm going to try to give you a little education. I mean, this is a place to get on with it, about how the legal system works and what these claims are and so forth. I'm going to try to avoid, except at the very beginning, the medical stuff because it's boring, number one. Number two, it's really not essential to the story. And number three, and most important, I really don't understand it myself. So what can I do? Okay, so let me just start off again, a little bit of an introduction about how I got where I was when this case came about and why it's so unusual. I mean, just extraordinary what happened for this case to get where it got with our client. Um, After law school, I served. I was a teaching fellow at Stanford for a year, and then I was with a San Francisco law firm for a year, and then I did 7 years of legal aid work in San Francisco. And at the end of that, I'd sort of reached the end of my string with legal aid. I applied for a couple of higher up jobs at legal aid that I didn't get, and I thought I was just going to be a working legal aid lawyer for the rest of my life. And then another Pomonoid, John York, who's the class of '67, didn't actually overlap with me, but he was the sponsor for Jake Smith, who's a good buddy of mine, and so I knew York through Jake. He started a law firm in Berkeley, and I said, okay, well, I'll open up I'm gonna rent space from him and just have my own law practice. And I did that for a year, and I was definitely not suited to that. And then the big thing was that my malpractice premium for my insurance, which had been like $300 a year, at the end of the first year, it went up to 3,000. And that's sort of what was happening with legal malpractice at the time. I hadn't committed any, or at least I hadn't been sued for any malpractice. Nobody had come after me, but it was just that's what was happening to premiums. So I said to York, give me shelter, basically. And I joined his law firm, which was doing the opposite of the kind of work that I had um, thought that I would be doing. But they were a great bunch of guys in Berkeley. having a good time. And so I joined the firm as an associate. Um, and what we were all civil litigators. In other words, we didn't do criminal stuff and we didn't do business transaction stuff. We didn't do wills and estates. We didn't do tax. We did civil lawsuits and we defended them. And we did what was called, and it's like the lowest of the low, insurance defense. And that is, we not that we represented insurance companies, although we did it on occasion, um, but we were hired by insurance companies to represent their insureds when they got sued. And usually that was under a homeowner's policy or a uh, apartment package policy, sometimes under a business policy, but not everybody knows this. But when you get homeowners insurance, I mean, you're buying it for fire. You're buying it for when you suffer a loss that you'll be compensated, you hope, directly by your insurance company. But there's also a part, and some of you probably know this very well, there's also a part of your homeowner's insurance that is liability coverage. And that is if you get sued by somebody, your insurance company will defend you. They'll pay for a lawyer to defend you. And that lawyer is that lawyer's client is the homeowner, not the insurance company, but the insurance company's paying the bills. Um, and there's a lot we were involved in. So, we insurance agents, people don't ask about, nobody knows about that. That's not why they buy the insurance, but it's really an incredibly valuable part of your homeowner's insurance because it covers you. And it's not just in the home. People think it's in the home. No, it covers your liability anywhere in the world. Um, if Tony Johnson was on tour in Europe and he got in an altercation with somebody and or he slipped and knocked somebody over and that person sued him, his homeowner's insurance would cover him for that. Now it only covers it covers you for accidents. It doesn't cover you for intentional acts, and it doesn't cover you for, if you sign a contract that you're going to pay somebody $1 million and then you don't pay them the $1 million and they sue you, the insurance company's not going to step in and pay the $1 million. It's supposed to be for accidents that result in bodily injury or property damage. Um, but just to go just a little bit deeper into the woods, there is in California law and in, I think, most law in most states around the country, insurance companies, the burden's on them. So supposedly in the law. So if you get sued and the insurance company thinks, well, that's something you did intentionally, or that's something that was a business thing, or that was an auto thing because it doesn't cover auto, that you have to get that under your auto insurance. We're not going to cover it. But if there's something in the complaint against you that might lead to coverage, because they also say you were negligent in the way you maintained your house, and so I tripped and fell, or whatever they say. The insurance company, the duty to defend you in the lawsuit is broader than the duty to indemnify, that is to pay off the claim. So the insurance company has to defend you if there's any possibility of coverage. And then if it turns out that you lose and there is no coverage, they could say, well, we defended you, but there's no coverage for this. But that doesn't happen very often, usually, mainly because 95% of cases settle. And the insurance company can't make you settle with your money. So you just go into and we would tell our clients this, when we go into a mediation, you don't have to pay anything. And even if the insurance company is saying, well, we're defending you, but we're not going to indemnify you if you lose this case. You say, so what? I'm not paying a penny. You go ahead and defend me. We'll deal with this at the end. And very, very, very few cases where after defending somebody all the way through, the insurance company says, guess what? We're not going to pay the judgment. And we had a couple of those in our office. Anyway, so that's what I'm doing. I'm defending. As my daughter said, when I was supposed to I volunteered to give a seminar at her elementary school on the Salem witch trials and civil rights and all that. She said, she didn't want me there, of course. She said, Dad, you don't know anything about that. You're a trip and fall lawyer. Uh, which she had a very good understanding of what I basically did. It was people tripping on somebody's sidewalk or somebody hitting a baseball through somebody's window. Actually, the really simpler cases like that, the insurance companies would handle in-house. They would have their own lawyers and they'd handle them, and some of them are good and some of them are not so good, but it's not a great job to have. And so they weren't the top lawyers, but they'd send us cases that were a little more difficult. We had one of our lawyers, and we all had our specialties. One of our lawyers, who later became a Superior Court judge in Contra Costa County, he was our party out of control lawyer. That's the pair, and I'll just give you a quick example. And there were a lot of these. Parents leave town for the weekend. Kids put up signs all over the neighborhood. Big party at our house. Beer, $5 for all you could drink. A whole bunch of people come over to the house and violence ensues. And parents and kids get sued by whoever is the victim of the violence. And I mean, there were bad ones. I mean, there were shootings and there were people that were in wheelchairs because of things that happened at parties. And so we defended those cases, and that was Steve's area. My area was mostly landlord tenant because I had all this experience from legal aid representing tenants. And so now as my legal aid colleagues, many of them said, and one of them said it recently, 30 years later, Alice and I ran into one of my old colleagues and he said, yeah, you went over to the dark side. Because I was representing landlords who got sued by their tenants for this or that. And I used to say my excuse was, I used to be a San Francisco. I still represent the downtrodden and oppressed. In San Francisco, that was the tenants, but in Berkeley, that's the landlords. And I did have, during the course of my practice, two cases going at the same time, two totally different cases, two totally different things, but they were both landlord tenant. And in both of them, the tenant who ended up suing said exactly the same words, word for word, to the landlord at the height of the controversy, which was, you can't do that to me. This is Berkeley. So, that's kind of, and also York was the only insurance defense lawyer who was also a member of the Lawyers Guild, which is the far left lawyers association. And he liked to think of himself as a sort of a communist. And he said, oh yeah, no, we're insurance defense. We're not the bad guys. We're redistributing the wealth. We take all the insurance company, we settle all these cases. So we're giving all these people money that they don't really deserve. We're just redistributing the wealth. So anyway, that's what we did. And we also, every once in a while, a business would get sued and they would have a claim for coverage that, it was an accident. They didn't do anything intentionally wrong. And that's how we got these cases, or the first case. And that was, we had a client was, we were assigned to defend them in this case. And it was a Mon-Pa operation, Buckman Company. Buckman Company was Pam Buckman and her husband. And what they did, they were consultants. And she was a nurse, a registered nurse, and she had done work with medical device companies that made medical devices. And she set up this company to shepherd medical device manufacturers through the FDA approval process for their devices. And just a bit about FDA. The FDA has been around forever, but FDA only started regulating or having jurisdiction over medical devices as opposed to medicines in 1976. And I've read a bunch of things that people said about why that happened. And it's funny because I always thought it was because of breast implants that went wrong. I read another thing that said it was from IUD uh, implants that went wrong. And then there's another thing that it was from actually from heart, what do you call them?
Pacemaker.
Pacemakers that went bad. Anyway, everybody said this is a new era. It's not just medicines, it's doctors are using devices, and we ought to regulate these devices, and we ought to test them, or you can't do blind tests because you can't put a you can't put a placebo into somebody's spine or a placebo pacemaker, but uh, they had other ways which were very expensive. And I read somewhere it usually would take 1,000 hours of testing and prep time to get approval of a device. But they had exceptions, and that's because they started in 1976. So they said, well, we're not going to start all over again and say every device that every doctor's using uh, has to go through this process before they can use it again. So they exempted devices that were already in use uh, for the use that that device was being used for. And you had to there's a approval process for that, but it was easier than the process of starting from the very beginning. So that's everybody wanted to get through that exemption and say, look, my device was out there, it was being used, it was being used successfully. We don't have to do this whole approval process. Okay, these manufacturers came up with this device, which is called a pedicle screw. And it's a screw and a plate. And I guess now we can get slide one, if you would, Tony. And this is one illustration that I found recently, when I was preparing this. And I don't think this is actually the one that we used, but there's little screws in there, and that's a plate. And this was to be used in aid of spinal fusion surgery. Um, when a surgeon is going to do a spinal fusion and he wants to lock it in place and, aid in the recovery and strengthen the spine. And so there's a part of the spine that's called the pedicle, and you put this screw into the pedicle, and it connects the parts that you're trying to fuse, and it has screws. And so that's a picture that I got recently of one. But I think what's really more interesting is how you put them in. So if you go to the next slide, this is the toolkit. This is two parts, and then the next slide is the third part of the toolkit that a doctor would buy in order to do this kind of surgery. And it's like screwdrivers and wrenches and stuff like that. And if you look at the screws, they're just like screws, like you could buy in a hardware store. And next slide. That's the third part. There's the clamps. This is what you're going into somebody's spine, and that's a fairly complex and sensitive part of the body. And you're putting these screws in. And then the next slide. So this shows you, it's the same picture, top and bottom, the same pair of pictures. I don't know why there are two of them there, but anyway, on the left is before the screws are put in, and on the right is the screws in there. So the white patches are where somebody's had pedicle screws and plates put in their spine. So uh, they want to get the FDA now has to approve this, and the doctors want to get the manufacturers want to get FDA approval. So they hired Buckman Company, one of them, Acromed, hired Buckman Company to shepherd them through the process. And so the first thing they do is they apply for exactly what they want to do. They apply for the bone, the plate and screw combination to be used in spinal fusion. And the FDA looks at all the documentation that they come up with of people having done it before, and they say, no, this is not the same. This is not what has been done before. You can't get in this way. And so they amend their application and they do it again. And FDA says no again. You're going to have to go through the whole long process and you can't do this. So they come up with another plan. And this plan is we're not going to go in for approval of this as a combination device for spinal fusion. We're going to go in for each of the parts individually, the plate and the screws. And we are applying for use in the long bones, which are the arm and leg bones. And they could show they could show that these things had been used. Similar plates had been used and similar screws had been used in the long bones in the past. And so they applied for that all the time with no intention of ever using them in the long bones, only in the intention of using them in the spine. And the FDA said, yeah, oh, that's fine. And they got approved for use in the long bones. As they planned, they were never used in the long bones. They were only used for spinal surgery. And they were promoted by the manufacturers. They medical schools, medical associations had, their gatherings where the manufacturers paid, tons of money for people to come and get educated on how to use these things and, in a promotional way, and ended up being hundreds of thousands of these operations were being done with, mixed results. And the thing that you have to understand about this, and the reason that the FDA didn't do anything about it, is because the FDA does not regulate the practice of medicine. The FDA only regulates in terms of devices. It only regulates the marketing of devices and what you could say is FDA approved and what you can't say is FDA approved. So these things were marketed for use in the long bones with FDA approval. They were not marketed for the spine. But another thing about the FDA is that the FDA knows full well that there's all kinds of medical procedures that are done with devices that have not been approved for that use. And there's a name for it. It's called off-market use. You're using it for something that it was not approved for. And there's all kinds of examples of that. I believe I know we have doctors, somebody could correct me if I'm wrong. I think the abortion pill originally, maybe now it's different, but the abortion pill was not licensed by the FDA for use for abortions. It was for something totally different. And they found out you could use it for abortions. Now, a competent physician is going to tell a person, the FDA hasn't licensed this for this use, but we think it'll work. We think it's a good idea, and we think you ought to do it. Or I could advise you, I could tell you the risks and all that, but I have to tell you, it's not FDA approved for this use. And I had eye surgery on both of my eyes with LASIK. And at the time, LASIK was only approved by FDA for one eye at a time. And I had both eyes done at the same time because the guy who did it, and he knew I was a lawyer, and he knew I practiced civil law. He said, look, this is not FDA approved for both eyes at the same time, but you really ought to do it. There's no reason not to do both eyes at the same time. It's going to work, and you don't want to come in for two operations. So let's do it. And we did it, and it worked fine for me, not for everybody. But so it is a known value in medicine for physicians to innovate, to try new things, to do things that aren't approved, and to do things that they can't get the millions of dollars that it would require to get approval if they didn't just try it out. And so off-label use is recognized, and people do it all the time in all kinds of different ways. So the FDA knew that these manufacturers were doing what they were doing, which is advocating off-label use for this product. Okay, sometime in the 1980s, but people are having bad results. And it's easy for there to be a bad result with these things. The screws can come loose. They can be implanted imperfectly in the first place. If they're not put in exactly where they should be and they impinge on spinal nerves, you got big problems. And so, the normal thing to do when you have this kind of a problem is you could sue the doctor for malpractice for having done it wrong, and you could sue the manufacturer for product liability, that this is a defective product. And when you sue on negligence, and malpractice is a form of negligence, you have to prove that the doctor did something that was negligent. And in medical malpractice, that means it was outside the standard of care of a doctor practicing in that area. So to prove malpractice, you have to get experts that say, no, a competent physician practicing in this area would not do this operation. Or if the guy really did it wrong, he would have done it right, and this guy did it wrong, and the way he did it wrong was outside the standard of care. You sue the device manufacturer, you have to prove a defect in the device. But you don't have to prove that they were negligent in making the device. You just have to prove, that's called strict liability. If the device is imperfect, if the device is defective, if the device has a defect and that defect causes you harm, you win, the manufacturer loses. But you have to prove that it's defective, and that's not easy for product liability. So this guy in Louisiana, lawyer in Louisiana, has a client who has a bad result of one of these surgeries. And he sues in Louisiana state court, and he wins a big judgment. And he decides he's got another client and he's going to sue. But I think the lawyer, I knew that I met this lawyer because he filed a suit in California, and we ended up defending it. And I met him, and I think he told me, either he did or somebody else, that the reason he filed in California was because he liked being in California. And he was thinking about moving to California, and he did eventually move to California. So how to get the case in California? Well, Buckman Company, which had advised these manufacturers, was a California company. So he filed suit on behalf of this one client from Louisiana who had a bad bone implant, screw and pedicle screw and plate implant, and had a doctor in Louisiana and had a manufacturer that was in Illinois. But they had Buckman Company that advised in the FDA process and said, okay, we're going to sue in California. We have jurisdiction because Buckman Company's there. And our theory against Buckman is Buckman defrauded the FDA, and we were injured. My client was injured as a result of that fraud. And it's not just Buckman Company, the manufacturers and Buckman Company defrauded the FDA because they told the FDA they were going to use it for one thing, and they ended up using it for something totally different. And that's fraud. And fraud, for your basic thing, fraud is that you make a representation of something that you know is not true with the intent that the person that you make the representation to is going to rely on that representation and is going to act accordingly, and that the plaintiff is injured as a result of that misrepresentation. So they said very simple, you misrepresented it to the FDA relied on an approval, and we got hurt, and we're the plaintiffs. And that's directly because of the FDA approval. So State Farm Insurance hires our small firm to represent Buckman Company in this litigation. The manufacturers have their own counsel, and we have a district court in San Francisco, and we win the case. And I'll tell you, this was 30 years ago. I don't even remember exactly the grounds on which we won the case. I know it had to do with the fact that it was in the wrong jurisdiction. That the court said, "Why are you suing in California?" Everything in this case, the doctors in Louisiana, the patients in Louisiana, the manufacturers in Illinois. I don't see enough of a nexus with California for you to be here. And I know that had something to do with it, but I think we had arguments about, can you really sue? Can an individual sue for fraud on the FDA? And that was part of it. But anyway, the case got thrown out. We win. Next slide. Okay, this slide, this is funny. This is, I framed this. I had to take it out of the frame to take a picture of it. I found this letter like 20 years after it was written. This is a 1991 letter from our client, Pam Buckman, to State Farm, thanking us for telling State Farm what a great job we did on her case. That she's just thrilled, she's wonderful, and she's not just saying this because we won. It was because of how we handled it. And me and Scott Burrish were the two lawyers working on it. We were just wonderful people. Well, I framed this, well, it is the nicest letter I ever got from a client, but I have another excuse for framing it, is because the last sentence of this letter is the epitome of irony. I think the epitome of irony, because the last sentence says, "Hopefully, we will never need them again. But if so, I would not consider going anywhere else." Okay, she wrote this letter on July 22nd, 1991. Within the 10 years after that letter was written, Buckman Company got sued well over 1,000 times. Well over 1,000 times. And we represented Buckman Company in every one of those lawsuits. If we had wanted to, now we did almost nothing. In fact, in most of the cases, we did nothing at all. If we'd wanted to, we probably could have gotten away with billing State Farm for hiring 10 attorneys or 20 attorneys and fully defending each of these cases, but we didn't do any of that. And let me tell you why they got sued. And this is pretty much agreed that this happened. In I think it was 1993. Actually, I don't know exactly when it was. Oh yeah. December 17th, 1993, there was a show called 2020, which was kind of an ABC version of 60 Minutes, a news magazine thing. They did a show with Barbara Walters and Hugh Downs about the menace of these pedicle screws. And what they had was they had a whole bunch of people. They did this expose of how the FDA approval had gone and the fact that it was never approved for this use and that thousands of these operations are being done. And they had a room full of people who'd had the operation done. And Hugh Downs asked them, would all of you who think your operation went wrong stand up? And this is all rehearsed, of course. And basically none of the people stood up. And somebody says, we can't stand up. you know. Uh, uh, and then they show the audience, and then they're in wheelchairs, and
Ah,
they're and they're telling their stories, and their stories are like, my I had some back pain. I went to my doctor. He sent me to this surgeon. The surgeon said, "Well, you got to get these. You got to have. We got to do spinal fusion, and we'll use these plates and screws, and it'll be fine. You'll get rid of your back pain." And now I can't walk. You
oh
know,
God.
uh, you know, uh, and they're so a lot of people who'd had this operation and a lot of lawyers said, there's something we could do here. So somewhere close to 10,000 lawsuits, individual lawsuits were filed, and they were filed in federal court. And the reason you could get to federal court, this is not a federal issue because you need to know the the FDA, the enabling legislation that created the FDA, and then the device amendments that brought in devices specifically say we're not creating a private right of action under this statute. We're setting up regulatory scheme, and we're setting up a regulatory agency to take care of that scheme, but we're not establishing a federal right to sue. So all these people are suing under state law, state product liability law, and state uh, uh, malpractice law. And the fraud is it's common law fraud. This is just a fraud. They made a representation and it was false. They knew it was false. The people relied on it. We got hurt. It's state law fraud. It happens to be fraud on a federal agency, but it's state law fraud. So what they do in these cases is called mass tort litigation, and there's lots of them. Oh, and the way they get to federal court is on basic diversity of citizenship. The federal courts handle two kinds of cases. They handle cases that are based on federal law, and that's what they really want to do. That's what the federal courts are there for. But they also handle cases that are between people of different states, because they say it wouldn't be fair that you're in one state or the other state because it's one party state against another party state. So the federal courts will handle those kind of cases, and they don't like those cases. They don't want auto cases that are, they don't want these kind of personal injury cases or property damage cases. But anyway, but they have to take them. And it happened, that all these plaintiffs were in different states than the manufacturers, and different states. You need to have a malpractice against a doctor from a different state, or else you didn't bring the malpractice, you just brought the product liability. And so these are all on diversity of citizenship. So you got cases all over the country. And there's thousands of them in thousands of district courts, federal district courts all over the country. Federal courts have a system for handling this because there's a lot of this mass tort litigation, not just for these, but for other devices and whatever. And they take all the cases and they move them to one district in the country, which is chosen by a panel that decides there's a judge here who can handle it. And all those cases go to that one district, and all of the preliminary stuff before trial is handled in that district. So all of your initial discovery, all of your initial motions, all of that stuff is in the coordinated case in that one district. And then and all your settlement discussions. You're having mass settlement discussions of these thousands of plaintiffs and the defendants. So that's all handled in the one district. And then if there are cases left, if you get through all of that, then the cases go back to the districts that they came from for actual trial. But you do everything. So these all got sent to Pennsylvania, Eastern District of Pennsylvania in Philadelphia, and a very experienced judge was assigned to it. And the cases have, these thousands of plaintiffs, and it's already 10:45. I got to go quicker. There's 90 some defendants, all the doctors, all the manufacturers. They also sue the medical associations that put on the trainings. They sue the medical schools that put on the trainings. And so there's 90 defendants. And little Buckman Company, we're the 90th. We're the least important defendant. Well, there's a motion to throw out the case, just the part of the case that's fraud on the FDA, because there's an argument on both sides about whether there can be such a thing as fraud on the FDA. And it's state common law fraud, but the defense is no, that's preempted. You can't do that. You can't have every state deciding what's, right and what's wrong. This is a federal thing. It's preempted by the federal law, and only the feds can enforce it. Individuals can't enforce it. So that's the argument on just that one issue. And so they have a hearing, and Scott Burrish flew from California to Philadelphia to appear at the hearing on that. And the hearing went for a couple hours. And the guy who was managing the defense, who was a retired federal court of appeal judge, who was managing the defense for all these thousands of cases, he tells the court, well, there's one more defendant that wants to speak, and that's Buckman Company. And Scott Burrish gets up, on this issue. And Scott Burrish gets up, and the judge says, I've heard enough. I don't really need to hear. So the only record of us in the trial court on this is the judge saying, I've heard all the arguments. I don't need to hear anybody else. Okay. So what happens? The judge rules there is no such, it's preempted. There's no fraud on the FDA. So that claim is out. And next slide. And so this is a report from a reporter. Court grants Buckman Company's motion to dismiss Omni complaints. The Omni complaints were the complaint with all the, everybody involved. And the reason it says Buckman Company wins is because Buckman Company, out of the 100 defendants, was the only defendant that was only sued for fraud on the FDA. We weren't sued for malpractice because we weren't doctors. We weren't sued for product liability because we didn't make any product. We were only sued for fraud on the FDA, and we were the only defendant only sued for fraud on the FDA. So the result of that is nobody else can appeal, because you can only appeal when the case against you is over. And everybody else still had cases going against them. We were the only ones. Now, there's a process. You can certify a question to the Court of Appeal. The district court judge could have said, this is a question the Court of Appeal ought to decide, so I'm certifying it to the Court of Appeal, and the whole question will go up to the Court of Appeal. But he didn't do it, and nobody really knows why he didn't do it. Everybody asked him to, and he just didn't do it. So the only people that could appeal was Buckman Company. And so we went from being the 90th most important defendant in the case to being the most important defendant in the case on this issue. And we appealed to the Third Circuit. And because my time is running short, I will give you the short version of this, which is also sort of the long version. We lost. The Court of Appeal in the Third Circuit said, yeah, there's a cause of action. We think there's a state law cause of action. That's not preempted by federal law. You lose. And the plaintiffs win. And, go back to district court and get on with it. So we have a choice. We can, do that, which of course we don't want to do, or we can petition for hearing in the United States Supreme Court. And the other parties tried to get entered into the case, but they couldn't get entered into it. But they filed what is called amicus briefs. They supported us, but we were the ones. We're filing for a hearing in the Supreme Court, Buckman Company. And the end of the Supreme Court term, when we applied, comes up, and the Supreme Court has they accept, I think, 30, 40, something like that cases. They got 1,000 cases that they don't take. And in our year, and I'm not sure how often this happens, but in our year, there were a few cases, I think it was 9, where the Supreme Court said, we don't know if we're going to take this. We want an opinion from the United States government, the Solicitor General's office, as to whether we should take it. Because the US government wasn't involved in the case. It was these individual plaintiffs against the manufacturers and the doctors and us, and the medical associations. But the US was not part of the case. So then it goes to the Solicitor General's office to decide what position the United States is going to take. So then our job becomes lobbyists. We're going to lobby at the federal government that they should tell the Supreme Court to take the case, and hopefully take the case and come in on our side, and say that it should rule in our favor. So Scott Burrish went to DC and lobbied at the Solicitor General's office, and I lobbied at the FDA, which we knew that Solicitor General's office was going to consult with the FDA on this. And so I went, and I'm giving myself a larger role in this case probably than I deserve, but that's my prerogative. At the FDA, this was 2000, was the last year of the Clinton administration, and it was still Clinton FDA. And Clinton FDA was very consumer oriented. And when I went in and met with these FDA people, their attitude was, no, we think, we can't enforce this around the country. We like private enforcement. We think there should be private enforcement. That's our view, basically. And I said, well, let's think about this for a minute. Your view is these cases should go ahead, and they're going to go ahead in thousands of district courts around the country. I said, the defense that we're talking about now is this legal defense that there's no such cause of action, and that's what's come up to the Supreme Court. There's no such thing as fraud on a federal agency. But let's say we lose on that, and the Supreme Court doesn't take the case. So that means all these cases go back and they go back for trial. Well, we have another defense that we can't bring up in preliminary, but we're going to bring it up in every single one of these cases. And that is, there was no fraud on the FDA. The FDA knew exactly what we were doing. They knew that we intended to put this into the spine, and that we were getting approval for the long bones because we would market it for off-label use. The label would say it's only for the long bones, but we would be marketing it that you can off-label use it in the spine. And the FDA knew that when they approved it. And they said, well, we have to approve it but this is what they're going to do. And to prove that, there's a bunch of people from the FDA who have left the FDA, and they are ready to testify for the plaintiffs that this is terrible stuff and it shouldn't have been used and blah, blah, blah. But there's a guy at the FDA. We know who he is, and we've seen his memo. And he wrote a memo during the approval process that says exactly what we were doing. He said, these people are applying to get it for the long bones, but when they get it, they're going to market it for off-label use in the spine. And so that's our defense. The problem is that guy still works for the FDA. And in order to take a deposition from a federal employee in an agency, you have to have permission from the agency head. And of course, we'd asked to take this guy's deposition, and the agency head had said, no, you can't do it. Well, you do have a remedy for that. You go to court and you tell the court, we need this deposition. So despite what the head of the agency said, the court has to order that this deposition can be taken. Well, we hadn't done that yet because we weren't at that point of the case. But I said to the FDA, we're going to do that. And no judge is going to deny our motion, because the judge is going to see our whole defense is based on what this guy said, and he's in the FDA. And of course, we have to be able to depose him. And I said, he's going to spend the next 10 years of his career not doing any FDA work. He's going to be testifying in every federal court in the country in the trials as our defense that we didn't defraud the FDA, because that's our evidence, you know? So if that's what you want the FDA to have to go through, okay, that's what's going to happen. So the result of that was the FDA and the federal government came into the case. They didn't come into the case. They filed briefs in the U.S. Supreme Court stating that the Supreme Court should take the case and the Supreme Court should say there's no such cause of action as fraud on the FDA because it's preempted by federal law. So that's what they did. And the Supreme Court took the case. And we hired a Supreme Court advocate who was somebody recommended to us by my father. My father argued a lot of cases in the Supreme Court, labor law cases. And he had a partner, former partner, who was still arguing cases in the Supreme Court. And so I called him up and I said, we've got this case. He said, oh, I know all about your case. I'm on the other side. But he said, here's the guy you want to talk to. And he gave us the name of a very experienced Supreme Court litigant in administrative law, agency law. And we hired him and he argued the case for us in the Supreme Court, which happened to be argued on the same day in December of 2000 that Bush v. Gore was decided in the U.S. Supreme Court. And so the day that our case was argued, the decisions in one of the Bush v. Gore cases were read from the bench. So on the day that our case was argued, the court was full of reporters, TV reporters, journalists, all kinds of people. It was absolutely packed. I was sitting in the court next to Nina Totenberg from NPR, which was kind of fun. And then they read the decision from the bench in Bush v. Gore, and everybody left. It's like, you don't want to hear our case argued? No, they all left. Anyway, our case got argued. And by the way, by this time, okay, we've been gone from number 90 plaintiff defendant in the case to most important defendant in the case. Now, when it got to the Supreme Court, we were more important than the case because it was not just there were other kinds of cases, not just fraud on the FDA. There's all kinds of fraud on other federal agency cases that were the same principle was being argued. Can you do that? Is it preempted by federal law? Just one example was FAA, Federal Aviation Administration. People that were in plane crashes, they sued the airline for negligence. They sued the plane manufacturers for defects in the planes. But now they had this new theory, fraud on the FAA. You disguised from the FAA, and so we're going to sue you for fraud. And the good thing about the fraud claim, in addition to bringing in additional defendants, is you could get punitive damages for fraud. You can't get punitive damages just for negligence, and you usually can't get punitive damages for product liability, but you could get punitive damages for fraud. So there were a lot of airplane crash cases where there was a fraud on the FAA claim, and there were other ones all around there. So we became really important. And because it's time, or I'm going to leave a minute for questions, I will just tell you that we won. We won 9-zip. It's a court you wouldn't recognize now. Rehnquist gave the opinion. O'Connor, Scalia, Kennedy, Souter, Ginsburg, and Breyer joined the opinion. There was a concurring opinion, which is interesting. I mean, they agreed with the result, but Stevens, who was a liberal justice, and Thomas, who's the only one that's still there now from that court, they had a concurring opinion. And what they said was, we agree that this should be thrown out, but only because the FDA is not claiming that they were defrauded. If they were claiming that they were defrauded, then we think maybe there would be a private cause of action. But since the FDA doesn't claim that they were defrauded, you can't have a private cause of action. And I've skipped. Go ahead to the next slide. That's the decision. That's the actual decision in the trial court that dismissed the case against us, and that's what we appealed from. Next. That's the Third Circuit decision that says you lose. There is such a claim. Next. It's only one of the briefs that I still have. That's or one of the few briefs that I still, that was our reply brief in the Supreme Court in favor of our case. Next. That was the brief of the United States coming in on our side, and we gave half our argument time in front of the Supreme Court to the Solicitor General's office to argue in our favor. And then the last slide, that's a copy I got now of the actual decision from the United States Supreme Court. So we won, and that's the end of the story. Any questions?
But you said that wasn't the end of the story. You said that then somebody showed up with a pea shooter and.
That was us.
Oh, okay. You were the pea shooter.
We were the pea shooter.
Okay.
David beat Goliath in the Court of Appeal.
Okay.
Goliath was the manufacturers. The manufacturers lost in the Court of Appeal. And then we came in and won it in the Supreme Court.
Got it.
And as far as I know, just as a little aftermath, the FDA eventually did approve these devices for use in the spine, but only for use in severe spondylolisthesis and other conditions that I can't remember the names of, only for severe back trauma, not for just, oh, my back hurts. And my view of it, I think I said at the very beginning, from my totally unprofessional, in terms of medical knowledge, view was, yeah, these things were being put in people's backs when they shouldn't have been. Because people should be told, I'll put this in your back, but you may, if it goes wrong, you may not be able to walk. And, one kind of person is going to say, forget it. And another kind of person is going to say, I can't walk now. So, do it. So that's that story. In terms of our involvement, just one little note I think is kind of funny. Buckman Company continued to have some legal stuff, and Scott Burish, my partner, continued to work for them. And then Pam Buckman went and worked for another company, a totally different company that did Botox. And they were getting sued all over the place for, Botox that goes wrong, because Botox is it's bad stuff. So he got all involved in that. And then the company went off and they were called Thermage. Company was called Thermage. And they went off and did other things. And Scott sort of followed this trail and was working for them. And then the last jury trial that I had in my career in 2019, which had nothing to do with any of this, it was a landlord-tenant stuff. But it turned out there was an alternate on the jury. She was on the alternates, and the alternates did not get called into the jury. They never were on the jury. So none of this mattered at all, but she was an alternate. And she realized halfway through the trial that I was Scott Burish's partner, and Scott Burish was her lawyer. And because she was with one of these companies that ended up, and so she got a call from Scott. I won the case. It was a miracle that I won the case. It's a whole nother story, but I won the case, and she called Scott and said, I think I was on the jury, and I was on the alternate on a jury, and your partner. So he gave me her number. I called her up. She told me all about her view of the trial, which was very interesting. But she'd never, since she was an alternate, she was never in the jury room. She didn't deliberate, so there was no prejudice. But if she'd ever got called into the jury, she would have said, Judge, I've realized that guy's my lawyer's partner. So anyway, that's the end of the story.
So thanks, Fred. This is really fascinating. I actually am involved with the same entity in the FDA because it turns out that biomarkers are also part of the devices section. So there's a lot of work right now on trying to find biomarkers for Alzheimer's disease. And I just had a conversation yesterday morning with people who are looking at biomarkers for Alzheimer's progression. And it turns out it depends on which company produced the biomarker. They need to be harmonized, and there's going to be this really big FDA issue of if you approve them for clinical use, how do you tell doctors how to interpret, oh, well, I tested them say 2 years ago with this one, and I tested them now with this other one, and it's changed. What am I supposed to make of that? So the FDA, and I've been involved with ones that have been approved for other situations. So the process for approval really is very, very complex. And I've also been involved at the other side, with the drug approval and with off-label use of drugs.
Mm-hmm.
And that's, as you say, off-label use is a big deal. And we're actually kind of fighting at the moment with the physician, the physician for my son-in-law, who appears that he would benefit from off-label use of something that has only been tried in fairly modest clinical trials, but is very promising from these trials. And the doctor doesn't have any other options to offer at this point. And so I've had to come up with summarizing all the evidence from the other approved usages and post-market summaries of side effects and why we think this would be an appropriate thing for a 1-month trial, which is what the clinical trial was. And it's that, if it doesn't work, it doesn't work, but then they're not offering something else in the side effects. But this whole off-label use is a very, very interesting question. So I found it fascinating that your dealings with the FDA and that their sense of responsibility or not
Right.
for off-label use, though they do put black box warnings on drugs.
Right.
And then the clinical practice people will send nastygrams to people who give drugs in a way that violates the black box warning.
Right.
So things like, and Les, you'll probably know about this, the use of the atypical antipsychotics in dementia for delusions and hallucinations is a black box warning because it increases the risk of stroke or heart attack, like 5 or 10%. But if somebody is 98 years old and has Lewy body dementia and thinks that there's dead bodies on the floor in their house, maybe you're not too worried about a 5% increase in stroke over the next 5 years. If the off-label use or non-black box warning use, the black box warning use, it makes it so they don't think they can't use the bathroom because there's a body in there.
I didn't go through some of this in detail, and there's no reason to, but there's actually all different kinds of, and it's interesting what you said, Laurel, because there's 3 categories of devices, and this device was a category 3, and the category 3 is, and correct me if I'm wrong, because I've looked at this in 30 years, but category 3 is the ones where, hey, this could really do harm. And so we really have to regulate this. And category 1, they give the example that I saw lots of times is tongue depressors. You don't have to get FDA approval for a tongue depressor because it's not going to hurt anybody. So that they come in, and with these markers, I'd be interested that they decided it's category 3 I assume. Or I don't know, maybe they didn't.
I don't know because they're based on samples of things like body fluids, although things like imaging biomarkers. So if you do PET imaging, you have to give someone a radioactive tracer. And those are clearly in the dangerous zone.
Right.
But the interpretation of, say, a plasma sample biomarker for dementia, taking the blood sample is no more dangerous than any other blood sample.
Right.
And you don't have to warn people of anything other than, oh, you may bruise, you may blah blah blah. But the interpretation, if somebody says, oh my gosh, you have elevated plasma Alzheimer amyloid or whatever, that can be complicated.
Right. Anybody else have any questions?
Yeah, just real quickly, Fred. So the implication here is if you can't have fraud on the FDA, how does that fit into the controversy about the abortion pills and the review of and the potential that saying, hey, the FDA didn't do their job? Does that fit squarely into what you? I'm assuming this is a
I'm not
precedent
sure.
carried forward.
I was
Yeah.
thinking about that, and maybe somebody else knows. I think originally, I don't know that the FDA has approved the pill for abortion use. And I think that's what, it's sort of the argument that was being made was, look, you approved it for this other use, and doctors shouldn't be, and the FDA ought to disapprove it. I know the arguments being made now is that the FDA ought to disapprove it. And I don't know whether the argument is you should disapprove it because you've approved it for abortions and you shouldn't have done that. Or if the argument is you approved it for use other than abortion and now you should disapprove it for abortion because that's what it's being used for. I don't know which of those it is, but it is the same. I do know that originally, when it was used for abortions, it was not approved for abortions. It was approved for something else.
Yeah.
And I think what the FDA's, and all of our opinion has been, look, you found that it was safe. So the fact that you found that it was safe, it doesn't matter what you found it was safe for. You found that it wasn't going to harm anybody who took it. So there's no reason to go back and examine it again.
Yeah. Yeah. And it's been off label for 20 years. So it's like, come on. Yeah. But the off label is also where the what is it? The obesity shots,
Yes,
whatever.
I think
that was developed for diabetes, I believe. And they found that, damn, this also does this other thing. So you never know.
Yeah. And the thing is, and I think I've tried to emphasize this, somebody says, oh, this will work for weight loss. If you didn't have off-label use, you'd have to start at the FDA and say, hey, I've come up with this drug. Now I want to use this drug for obesity. And you'd have to go through a multi-year, multi-million-dollar process of getting it approved for that use.
Yeah. Which essentially would be innovation. I mean, you just,
This is the way you innovate. Yeah.
Yeah. Good. This is really good. This is fun. Thank you. Of course, I'm a lawyer, so I love stuff like this. And it's interesting how it kind of falls in your lap in a way you never would have thought.
And so many things about it. The fact that the guy decided to sue in Northern California and so brought in Buckman, and then Buckman gets brought into all these other things. And then the judge refuses to certify the question to the Third Circuit so that we're the only ones that can appeal. The whole thing was just incredibly improbable.
Yeah.
But it got me licensed to practice in the Supreme Court. And I did have only one other case, and it didn't really get to the Supreme Court, but the other side petitioned for hearing in the Supreme Court. And so I didn't have to hire somebody to file a response. I just responded. Although I told the client, I said, this is like when they used to say about buying a lottery ticket. If you your chances of winning are almost exactly the same whether you buy a ticket or not. And I said, on this opponent that petitioned for hearing in the Supreme Court, I said, the chances that the Supreme Court is going to take this are no different whether I file a response or not. They're not going to take it. It's not going to go to the Supreme Court. But I'll file a response.
That's
Which we filed a 4-page response. Most Supreme Court briefs are 30, 40 pages or more. And we filed a 4-page response. There's no federal question here. There's no constitutional question here. Who are you kidding? That was the end of that.
This has been really great. Just to sort of side comment on Laurel's thing, I was actually in one of those Parkinson studies, and having blood, spinal fluid looked at and so forth. But I think I'm only 1 foot in, 1 foot out. I think they decided I couldn't smell anything, and therefore I'm not a good candidate.
Yeah, I've been involved in their biomarker studies and approval of some things as a consultant, but yeah, this.
Well, back to you, Tony. It's I'm finished.
Thank you, Fred. That was very interesting, both from medical and legal aspects.
Well, thank you.
Okay,
Fred.
so we're looking for volunteers. I'm going to stop